is going to buy this property and have the contract recorded. Section 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. NB, NB, NB. Section 20 is the section that you must have a very, very, very good working knowledge of. Because Section 20 tells you who can record a contract against the property, within what period of time must the contract be recorded against the property, what happens if the contract is not recorded within the 90 days, what are the remedies of the purchaser in that case. And then you will note that there are two forms in the regulations to this act, which you need to know, which is not going to be given to you. That is the one for that's an affidavit and application for the recordal of the contract, and obviously the application to cancel the recordal of the contract. And note then, obviously, what the documents are that needs to be lodged at the deeds office for the recordal of the contract or the cancellation of the contract. Section 26 tells you, can certain money change hands for land which is going to be sold in terms of a contract? And let us just go one step back again. A contract to be recorded against property, and you must know that that is a contract which must be in more than 2 installments over a period of longer than a year. Now, sometimes the question is very tricky. They ask you how many installments and for what period of time. The majority of the candidates say 2 installments, 1 year. That's not true. It's a minimum of 3 installments, more than 2 installments over a period of longer than a year. So it's a year and a day. That is the minimum time, if you understand what I mean. And then the contract can be recorded. If the contract must be recorded against property, no money may change hands. There's just been a Supreme Court case of appeal where the judge clearly said that no money may change hands from purchaser to seller unless the contract has been recorded. So just keep that in mind. And if you haven't got the court case, Google that court case with regard to the Alienation of Land Act and the exchange of money. That's Section 26. Section 29A is the cooling off section. But ladies and gentlemen, you know, the amount there is still 250,000 Rand. I don't know who buys property for 250,000 Rand. So it's very seldom that you have a cooling off period, except with the other exceptions. But they have in the past asked you to enumerate the exceptions contained in the Section 29A of the Alienation of Land Act when the cooling off period does not apply. That is Section 29A. Also note that the Alienation of Land Act says you can never waive your right to this statutory preemptive right that you have if the contract is to be recorded. That is just in, I think it is Section 30 of the Alienation of Land Act. So once again, let us summarize now. For purposes of the Alienation of Land Act, against what type of land can a contract be recorded? What must the contents of the contract be? Within what period of time must the contract be recorded? What is the position if the contract is not recorded within that period of time? And who can record the contract? Those are the questions that you must be able to answer, and be able, the documents that you have to draft is be capable of drafting is the recordal of the contract and the cancellation of the contract, and note the documents that you're going to lodge with the Registrar of Deeds. So that is the Alienation of Land Act, and I'm going to step off from that now. So now we've got our deed of sale, we have our basis of our Alienation of Land Act. Now we're going to look at the first document that we're going to prepare. Now, I start with my, because I've got my deed of sale now, I start with my deed of transfer. Now, I say to you once again, it is very important for you to prepare your deed of transfer as if you were going to lodge it at the deeds office. So there are, I usually say there are 10 clauses in a deed of transfer. And those 10 clauses, you must be able to recite or know those clauses off by heart. And the first clause is your preparation clause in the top right-hand corner of your deed of transfer. You will have a preparation clause which will say, prepared by me, ... conveyancer, and now in terms of Chief Registrar Circular 3 of 2020, you must put in your LPC number. You will put in, you don't have to write out LPC number M0000. You must just put in a number there. Put 1, 2, 3, 4, 5 there. Every time you write it, 1, 2, 3, 4, 5. Don't try and use a number. Just put 1, 2, 3, 4, 5. Okay? So that is your preparation clause in your top right-hand corner. You must now also know what responsibilities does this conveyancer who has signed this preparation clause in the top right-hand corner, what responsibilities does he take? The responsibilities he takes is set out in Regulation 44, capital A, and it's A, small a, B, and C of the regulation. Only those 3 responsibilities that the conditions have been correctly carried forward, that if the documents are lodged in duplicate, that they are correct. So very, very few responsibilities that he takes, but look at that. So preparation clause, we know how to prepare. Now we come to the preamble of our deed of transfer. And this is, guys, I can categorically now tell you, that, and this is a tip, you're going to get description of parties in the preamble of the deed and in the vesting clause of the deed, or in the preamble of the power of attorney, or in the vesting clause of the power of attorney. There is a difference between the two. And here, I don't know if those of you that have my book, I've got a schedule in my book which sets out every conceivable person that you're going to be confronted with, how you will describe that person as a transferor in your preamble of your deed of transfer. That's all based on Chief Registrar Circulars 8 of 1983, which refers to estates and insolvencies and companies. 5 of 1994, persons married in community of property and foreign marriages. 27 of 2013, which refers to customary marriages. 1 of 2007, which refers to civil unions. 28 of 2013, which refers to companies in terms of the New Companies Act. So you have to be able to describe those persons in a deed of transfer in the preamble. And here, just a tip for you, and perhaps, you're going to say to me, don't underestimate my intelligence. I know this, but I'm just repeating it for those people that do not know it. In your preamble of your deed of transfer, you will never refer to the name, identity number, or status of a person who's acting in a representative capacity. For instance, if it is an estate, you will say, the executor in the estate of the late Alan West. And you'll stop there. If it's a trustee in an insolvent estate, you will say the trustee in the insolvent estate of Alan West. But you can't stop with Alan West now, because if Alan West is insolvent, he does have an identity number. Do you agree with me? And he does have a status. He's usually married. So it will be the trustee in Alan West, identity number, married out of community of property, or unmarried, or married in community of property to his spouse. So with a estate, and I'm speaking about a deceased estate, you can never refer to the identity number or status of the deceased, because he loses that as soon as he dies, and usually he gets an estate number. The estate number is not a prerequisite to insert into your preamble of your deed of transfer. While we're speaking about preambles, it is also very important for you to be able to note in an estate transfer whether the joint estate is going to pass transfer or whether it is only the executor. And here, ladies and gentlemen, I refer you to section 21 of the Deeds Registries Act. Section 21 says that, look, let me go back. Section 20 says the owner must appear before the Registrar of Deeds or his duly authorized agent. In the case, it could be a conveyancer. Now, with the owner of the property in an estate, obviously, if I die, it will be the executor. If I'm married in community of property, there's a joint estate. The general rule is the executor and the surviving spouse must pass transfer. Do you agree with me? If there's an asset in a joint estate, it is the executor and the surviving spouse that is going to pass transfer. Except, and there's 5 exceptions, if the executor is also the surviving spouse, or if the surviving spouse is also the executor. Secondly, if there was massing and adiation. Thirdly, whether they're only dealing with a share of the deceased. Fourthly, if the property was sold to pay estate debts. And the 5th one, if the property is being transferred to the surviving spouse. In those cases, you will not join the surviving spouse. If you do join the surviving spouse, you're going to lose at least 5 marks. Because you won't lose all your marks, but you lose 5 marks. Somebody said to me, but can't you just treat it as pro non scripto? No, because then we can treat the whole Deeds Registries Act as pro non scripto if you're just going to write in things that are not relevant to your deed of transfer. So with estate transfers, note on how you're going to describe your transferor in your preamble of your deed, specifically when it is an asset in a joint estate. Let us go further now to our second clause of our deed of transfer, and that is our causa. So we've got our preparation clause, we've got our preamble, which starts with be it hereby known. You don't have to study that because you've got prescribed form E. If they ask you to prepare the preamble, they never ask you to prepare a whole deed of transfer. They ask you to describe the transferor. Because if they ask you to prepare it, you will start with be it hereby known that A.N. others, or the full names, Alan, another other, appeared before me, the Registrar of Deeds in Pretoria on such and such a date by virtue of a power of attorney, dated so and so, given to him by, and then you will describe the transferor. So that is your second clause. Your third clause, actually I left out the heading, but be that as it may. Your next clause is your causa. You can only have 1 of 5 causas in a deed of transfer. Only 1 of 5. A sale, very seldom they'll ask you to prepare a causa for a sale. A donation, remember, and there's many answers, and I've seen answers which are incorrect in books, literature, notes, that say if there is a donation, it must be accepted. That is not true. After the Alienation of Land Act came into operation on the 19th of October 1982, no donations have to be accepted because a donation is an alienation and it has to be in writing, signed by both parties. So if I have donated the property to you today and you accept it tomorrow, the date of transaction is tomorrow's date, not I donated it today and you accepted it tomorrow, because you don't have to accept it. The contract will come into existence when the last party signed the deed. So your causa for a donation will be, and whereas the purist principle donated the property on the last date, whether it was accepted or whatever the case may be. Now, therefore, I hope that makes it clear. So sale, you will refer to the sale. Donation, you will refer to the date of donation. An exchange transfer, you can exchange one property for another property, whereas the purist principle, being the owner of the hereinafter mentioned property, has
Yeah, well, I think just jammed there. Yeah, I'm wondering now, why is Matala got his hands in the air, not talking? Oh, yes. Okay. So that,
Hey, hey!
like,
Alan?
Hi guys, somebody have a number we can perhaps call?
Don't you guys think we must phone lead?
I tried calling lead, but the number for Andres is just ringing, so I can't get hold of him.
I don't know.
I called lead, and it seems like they're trying to resolve the issue with Alan.
There's no answer at lead offices.
Dit is. Now? Hello? Andres, can you phone me and tell me if you can hear me?
We can hear you.
Can I continue? Can anybody tell me just where did I last, where last did you hear me?
So you were speaking about exchange was one of the 5 causa.
So you stopped hearing me right when I started with the causas. Am I right?
Specifically on exchange.
Did you hear anything about inheritances?
You got to number 3 of the causas.
No inheritance.
No inheritance.
Okay, I'll continue with the inheritances. You can mute your computers again, please.
So please start with the exchange causa.
I will start with the exchange. So we've finished with the sale and the donation. The exchange causa, as I said, it is just a causa where you're going to tell the story where so-and-so is exchanging the one property for the hereinafter property. With an exchange causa, ladies and gentlemen, I'm going to get to it when I do the Transfer Duty Act. The only big difference between an exchange transfer and a deed of sale is that the transfer duty is payable on both transactions on the higher amount of the property. For instance, if I exchange my property for 1 million for your property for 2 million, we're both going to pay on 2 million rand. So that is section 5(4) of our Transfer Duty Act, but I'll touch on that again. So the exchange transfer, nothing strange in exchange transfer except the causa where we have agreed that on such and such a date I will exchange the hereinafter mentioned property for the following property. And those transactions can be registered in different deeds offices or it can be registered simultaneously in the same deeds registry. So that's an exchange transfer. A rectification transfer, once again, and I said all your notes that you have, Gabi Leroux's notes, has examples of rectification transfers. My book has examples of rectification, but you cannot study a causa verbatim from a note. You have to apply the circumstances to the causa that you're going to prepare. You're just going to tell the story. Why are you rectifying this situation? Was the property erroneously transferred into this person's name? Was the transaction, was a certain property omitted from the transaction? Was the wrong earth transferred to the person? So you will tell the story there. So I don't think a rectification causa should be a problem. We will get to the transfer duty implications a bit later. Then inheritance. And I think I've been speaking for 15 minutes on inheritances and now only I find out that you didn't hear anything. Let us start with inheritances. The causa tells the story. And I want to say to you, and I've said it and I'm repeating myself now, I have been criticized for explaining to candidates to use the words and whereas and whereas and whereas and whereas and now therefore. You can use the words and whereas. I believe this is the manner that you can just mute your computers, please. This is the manner in which you're going to prepare it. You're going to say, and whereas so-and-so died on such and such a date. And whereas so-and-so was married in community of property to so-and-so. And whereas in terms of the joint will of them dated so-and-so, they bequeathed the hereinafter mentioned property to the hereinafter mentioned persons, subject to whatever the case may be. If it is subject to a condition of the will, you don't quote the condition of the will in your causa. You say, subject to the condition of the will more fully set out hereinafter, and you bring it in your conditional clause. Usually it is that condition which excludes the community of property, or it could be a usufruct, or it could be a preemptive right, or it could be a fideicomissum, or whatever the case may be. And then you will bring that condition in. So once again, with inheritances, ladies and gentlemen, you tell the story. I try to explain to you by way of an example. My wife and I are married in community of property. We make a joint will. We decide that on the death of the first dying, the property must go to our children, subject to a usufruct in favor of the surviving spouse. Prepare the causa. Now, we cannot do this in terms of section 45 because the surviving spouse is not receiving the property, so it must be a formal deed of transfer. You will start. And whereas so-and-so died on such and such a date. And whereas so-and-so was married in community of property to so-and-so. And whereas so-and-so and so-and-so made a joint will dated so-and-so. And whereas in terms of the joint will, they massed the estates and bequeathed the hereinafter mentioned property to the children, subject to a usufruct in favor of the surviving spouse. And whereas the surviving spouse ideated the terms of the will, because either she can repudiate or ideate. Now, therefore, so-and-so, the full and free property is being transferred to the persons entitled to. So with an inheritance causa, I say, it's like the exchange transfer and like the rectification. You cannot go and study precedents. You must know what must be contained in your causa, if that makes sense to you. You can read and you can study and you can recite it, but you must apply your facts that are given to you to the causa that you're going to prepare. Then I said, let us look at interstate. And here we must note on the provisions of section 11A, 11B, 11C of our Interstate Succession Act. 11A is if I die intestate and I left no children, then my wife, if I'm married, obviously, my wife inherits everything. If I have got a spouse, and if I'm married in community of property, she will be entitled to 1/2 share by virtue of a marriage in community of property, and she will inherit the other half share in terms of 11A. If I have no wife but I have children, and whereas so-and-so died interstate on such and such a date, and whereas the hereinafter children are entitled to the property in terms of section 11B. 11C is the one that candidates have a major problem with, because here you have a wife and you have children, and now you have to determine what share the wife is going to get and what share the children are going to get in this immovable property. And to determine that, you have to, the examiners have to give you the balance for distribution. And by way of example, I say to you, the balance for distribution of my estate is 2 million rand. I die and I have a wife to whom I married in community of property, and I die interstate. So now, first of all, and whereas so-and-so died interstate on such and such a date, and whereas so-and-so was married in community of property to so-and-so, and whereas the surviving spouse is entitled to 1/2 share by virtue of the marriage in community of property, because that gets taken out of the equation. And whereas now you must determine the other half share, which is 1 million rand. Who's going to get that? To determine a child share, you take the wife plus the amount of children and you divide it by that value, that 1 million rand. Now, if I only had one child, my wife would be entitled to 250,000 or child share, whichever is the greater. Now, if you take the 1 million and you divide it by 2, it's 500,000. So she's going to be entitled to 500,000 because it is larger than 250. And the remainder will go to the child. So my wife will get 1 million rand plus 500,000 and the child will get 500,000. To break that down into fractions, she will get a 3/4 share and my child will get a 1/4 share. And that is how you're going to describe them in your vesting clause of your deed of transfer. I hope that makes sense to you. So the causas, ladies and gentlemen, are important. If you go look at your old exam papers, how many times have causas been asked? Every time a causa has been asked. So if you can't prepare your preamble of your deed of transfer, your causa, don't go write the exam, because then you're going to fail. You're going to get a causa in the exams. And remember, your causa in your deed of transfer is exactly the same as in your power of attorney. So let's step off from our causa now. Let's look at our vesting clause. Also, you're going to get description of parties in a vesting clause. Married people, persons married in terms of customary marriages, persons married in terms of customary unions, certain persons married in terms of civil unions, companies, deceased estates. If I bought the property during my lifetime, and remember, your deed of transfer is prepared and it must be the facts as at date of registration. So let's say I bought the property last month and you get the instruction to transfer the property. The day you have to register the property, you determine that I've died. You can't transfer the property into my name because I don't exist. You have to transfer the property into the name of my estate. Here I refer you specifically to section 17.3 of the Deeds Registries Act. That if the property doesn't form an asset in the joint estate, you will register the property in the estate of the late Alan West. No identity number, no status. I lose that. If I was married in community of property and we bought the property during my lifetime, you will register the property in the joint estate of the late Alan West and surviving spouse Erna West. And Erna West has an identity number and has a status. It will be Erna West, identity number, status, unmarried. Let's say Erna West got married, which usually will happen immediately thereafter. It will be Erna West, identity number, married out of community of property, because now she's realized. But let's say she hasn't realized the mistake and she got married in community of property again. It will be Erna West, identity number, married in community of property to Paul, whoever he is, without his identity number and status. And then a section 45 will have to be done on that title deed. I hope that makes sense. Look at section 17.3. They love asking you whether to describe parties in your vesting clause when somebody has died. I then once again reiterate, CRC 8 of 83, 5 of 1994, 1 of 2007, 27 of 2000, 28 of 2013, foreign companies, they're 28 of 2013. So those circulars that have been given to you, you have to study them. That is your vesting clause. Your property description, ladies and gentlemen. Many people ask me, if I write in, I don't know if I've got people that are now attending this webinar and they're going to write in Pietermaritzburg, or they're going to write, you draft your property description as you would have done. Even if they tell you the property is situated in George, or it is in Bellville in Cape Town, or if it is wherever, you draft your property description as if you are lodging it at the Deeds Office Pretoria, irrespective of the property description. So in Gauteng, you will have the earth number, the township, the registration division, and the province. If they haven't given you the registration division, you can use any registration division, JR, JQ, whatever. They don't look whether you know what the registration division is. If it's a farm, you will say the farm with the name and the farm number, registration division, and obviously the province. Part of your property description is also the extent of your property. The extent of your property in your deed of transfer must always be in words and figures. And if it is hectares, it has to be correct to the 4th decimal figure. Just by way of an example, if you're transferring 1 hectare, how will you describe that in your deed of transfer? It will be 1,00,000. Okay? And then in words, 1,000. That doesn't mean that you've got 10,000 hectares, you've got 1 hectare, 1,00. So always, and they do subtract marks for this, if you do not give the 4 decimal figures. So your property description usually will be given to you, and if you have to rewrite it, if they say the property is in Bellville and they haven't given you the province or they're not going to subtract marks if it's Bellville and you say the province of Gauteng. Please just understand that they're not, there's other things that they're looking for to subtract marks than to determine whether you know that Bellville, you have to use the municipality and the administrative district, etc. So that is the property description. Look at specifically Regulation 28, 29, and 30. Those are the 3 regulations in the Deeds Registries Act that tell you how to draft a property description. If there is a share, you will set out the share in your property description as well. Then we come to the extending clause. Guys, ladies and gentlemen, colleagues, you're going to get extending clauses. I guarantee you, you're going to get an extending clause in the exams. In your prescribed forms, you have prescribed form TT and UU. Now, I need a whole day to go through extending clauses with you. And all that I can say to you, that candidates fail the exams because they do not know how to draft extending clauses. And I'm going to try and summarize this very quickly. Let us start with Form TT. Form TT is used when you are creating a new entity. Please write that down. Form TT is used when you're creating a new entity. When will you be creating a new entity? Just think now, when will I be creating a new entity? With a subdivisional transfer. With a CRT which creates a subdivision. With a partition transfer that creates a subdivision. With a first transfer from a general plan. With a consolidation. Those 5. You will be creating a new entity. The entity is then born with a new diagram. The entity is then born with a new diagram. And your extending clause will always read, as will more fully appear from general plan, so-and-so, or diagram, so-and-so, and lastly held by deed of transfer or certificate of registered title or certificate of consolidated title. So Form TT with the creation of a new entity, you will always start as will more fully appear from your diagram or your general plan, and lastly held by your mother deed, the deed from which you are transferring this new entity. Surely that can't be difficult. Surely that can't be difficult. Because you got the form. You must just now know, am I creating a new entity? There's just one subtle nuance here. If I'm doing a consolidation, I don't refer to my mother deed. I just say, as will more fully appear from consolidation diagram, number so-and-so. Because the 2 entities that I've consolidated, I've already referred to the title deeds above. So with your consolidation, there's a difference with Form TT. Don't refer to your mother deed because you have already referred to it. I hope that makes sense. That's Form TT. Now we go to UU. I've inserted a UU1 because if you're going to transfer from a TT, then you cannot use the form as it is in your prescribed form, because then you will have to say first transferred and still held, or first registered and still held. If you understand what I mean, because the diagram deed and the holding deed is exactly the same. If it wasn't for UU1, you would have said first transferred by deed of transfer so-and-so with diagram annexed thereto and also held by the same deed of transfer. So you're just summarizing it into one extending clause now, saying first transferred and still held by that deed of transfer with diagram annexed thereto or diagram relating thereto. If your diagram deed was a general plan, and I always try and explain to candidates, you can never annex a general plan. Why not? Because it is far too big to annex. It is more of a big thing. So you say first transferred or first registered by deed of transfer with general plan relating thereto. Okay? A general plan will always relate and not annex. A diagram will annex because it is a A4 document. If you are now transferring from a UU1, it will be first transferred by your diagram deed with a diagram or general plan, and lastly held by the deed. So you got 3 extending clauses. Actually 4 if you look at consolidated titles as well. But you got 3 extending clauses. A TT, which you're going to use for the creation of a new entity. A UU1 when you're going to transfer from a TT. And a UU2 when you're going to transfer ongoing transactions. And I urge you to go look at the questions in the old exam paper, specifically the last exam paper, because that question has repeated itself, I think, I don't know how many times. If you can answer those questions, then you would, and the penny has dropped, extending clauses should not be a problem. You should get at least 15 out of 15 for your extending clauses if the penny has dropped. I also just want to explain to you that with your extending clause, if your diagram deed is a certificate of title, you cannot say first transferred, because a certificate of title doesn't transfer ownership. It is first registered and still held with diagram. So, but you know, if you just read your footnote to your prescribed forms, it will tell you that. But you know, you should know it. You shouldn't be able to now go to the prescribed forms. You should be able to do this specifically. So I hope extending clauses has been explained to you, and that you will be practicing it on an ongoing basis. Then we come to the conditional clauses. Now, the conditional clause in a deed of transfer, it is a repetition of the conditions that's in your title deed, but you must know which conditions, because they're going to ask you, they're going to tell you the property is subject to the following conditions. Certain conditions lapse by merger, certain conditions lapse because they have racial connotage to it. So there, I urge you, and I just don't have the time to go through all the conditions which you must be able to omit from the title deed. But for example, you should know at this point in time that mineral rights and any ancillary rights to mineral rights and prospecting rights and those conditions do not get carried forward in the deed. So I'm not going to try and belabor this point. Then the rest of the deed of transfer, you got the prescribed form. So can I tell you now, in prescribed form, they're going to, prescribed form E, you must know how to prepare the preamble, the causa, the vesting clause, the property description, and the extending clause. The conditions when I do subdivisional transfers and when I do partition transfers and when I do certificates of registered title, then we'll speak about plotting and qualification. I'm not going to do that now because plotting and qualification is also an extremely difficult aspect, which I will touch on when we do those specific registrations. Then the next thing that we're going to come to, before I think I'll just finish the power of attorney, and then we will continue with questions and answers. The power of attorney for a deed of transfer. Once again, 10 clauses. And those clauses, you must be able to recite them in your sleep. And I usually, you know, I picture the power of attorney on 2 pages. Top right-hand corner, preparation clause. Prepared by me, conveyancer, Alan Nather, with my LPC number. You've got that. The conveyancer who prepares the power of attorney takes a major amount of responsibilities. And that's all set out in Regulation 44A, small c, d, e of the regulations to the Deeds Registries Act. You'll have to study that. It has been asked in your second paper, now your first paper in the past, what responsibilities does the conveyancer take? Now we know that the power of attorney must be prepared by a conveyancer, but it can also be prepared by an attorney or a notary, provided it is countersigned by a conveyancer. Now, unless the question specifically asks you that, don't now go and sign the preparation clause by an attorney and have it countersigned by a conveyancer. You haven't got time for that. I also want to urge you, and I'm not being facetious, but I saw this in old persons that wrote the exams, that the guy, every time he had to write his name out as a conveyancer, he said, Johannes Petrus Pochenpoel. You haven't got time to write such long names. You write Joe Poe, or the shortest name that you can think of that you're going to use there. If you have to insert an identity number of a person and they haven't given it to you, use your own identity number, because you know your own identity. Don't try and create identity numbers. And somebody said to me, but aren't you going to check if it's a male or a female in I? No, man, they haven't got time to check if there's males or females. You use your own identity number throughout. So there where you write your prepared by me, somebody asked me, must I sign the preparation clause? Please don't. Please don't. You haven't got time to sign preparation clauses. Because I see people are signing preparation clauses, the most fantastic signatures, and at the bottom where the transferor has signed, a beautiful signature there and 2 witnesses, and they've got the identity numbers in of the witnesses. And you know what happens? At the end, they say to the examiner, we didn't have enough time to finish this exam paper, because they cluttered it up with unnecessary information. The examiners know that it must be signed. They know that that the witnesses must sign there. So you don't have to put in signatures. So we've got top right-hand corner, we've got our preparation clause. Then we've got a heading, power of attorney. Now I've already seen in the past, power of attorney to transfer property in terms of the Deeds Registries Act 47. Rubbish, just power of attorney. Okay, so preparation clause, heading, power of attorney. Then we come to our preamble. Now our preamble of our power of attorney, remember our power of attorney, we speak in the first person. Our deed of transfer, we speak in the third person. It will always start with I or we. If it is somebody acting in a representative capacity, like an estate, like a trust, like a company, or whatever the case may be, it will be I, Alan West, without an identity. Remember, a person acting in a representative capacity does not need to have the identity number or his status reflected. I, Alan West, in my capacity as executor in the estate of Erna West, duly authorized hereto by virtue of a letter of executorship issued to me by the Master of the High Court, Pretoria, on such and such a day. You don't have to put in the divisions and South Gauteng and North Gauteng. They're not looking at that. They want to know, can you identify the executor that's acting in the estate, and what is the authority that is acting in terms of? If it is a trust, it will be I, Alan West, and Erna West in our capacities as trustees of the ABC Trust. If it's a Mortis Causa Trust, MT. If it's an Inter Vivos Trust, IT, duly authorized by letters of authorization issued to us by the Master of the High Court on such and such a day. If it's an insolvent estate, I, Jonathan Mashlangu, in my capacity as trustee in the insolvent estate of Alan West, identity number, status, duly authorized by virtue of a letter of appointment issued to me on such and such a date by the Master of the High Court, Pretoria. Finished. If it's a company, I, so-and-so, in my capacity as director of the ABC company, registration number, guys, registration number for the year 2000, 6 figures of the company. If you want to make it 5 zeros and a 1, that'll be the first company of 2020, and then the code of the company. If it's a Pty Limited, it's 07. If it's a limited company, it is 06. And so I can continue. You must know how to set out your company number. The directors, you don't refer to, never do you refer to the resolutions of a company, because the company cannot, the directors cannot act ultra vires the company. That is in terms, you know, the Turquant rule and the old section 36 of the Companies Act. So it's I, Peter Mashlangu, in my capacity as director of the ABC company, registration number, so and so. You write out registration number, you write out identity number, you cannot abbreviate it. Duly authorized thereto by virtue of a resolution. Stop. If you do say resolution taken at Cape Town on such and such a date, you won't lose marks, but you haven't got time, and is frowned upon, because then they know that you don't know that you don't have to refer to the resolution. So the description of your transferor in your power of attorney, once again looking at the joint estate, etc., is of the utmost importance. Okay. Just want to carry on with my power of attorney. I referred you to married persons, estates, customary marriages, civil unions, how to describe minors. Let us say the minor is selling the property now. Here we have to obviously differentiate between minors under the age of 7 and minors between 7 and 18. Minors under the age of 7, obviously no contractual capacity, both their parents must act on their behalf. So it will be Erna West and Alan West in our capacities as the legal guardians of Carl West. Carl West has an identity number. He gets an identity number the day he's born. And I see people are describing a minor as an unmarried minor. I'd love to see a married minor, if you understand what I mean. So that's tautology. It's a minor. It's not an unmarried minor. So in our capacities as legal guardians of Carl West, so and so, and if a guardian is acting in terms of a court order, obviously you will refer to the court order as well. So insolvent persons, foreigners, trusts, foreign companies, that's all those aspects that you have to look at when you are drafting the power of attorney or the preamble in your power of attorney. And then I also want to refer you to the provisions of section 69, 1 of the Deeds Registries Act and 69 bis of the Deeds Registries Act, specifically when you are dealing with fideicommissions and usufructs. So there I want you to know that the usufructuary can join the bare dominium owner in transferring the property. How are you going to describe them? And the fideicommissory heirs, if they are ascertained and competent, can also join the transferor or the bare dominium owner or the fiduciarius, the fiduciarius in transferring the property. Those questions have also been asked on an ongoing basis. So I say to you, go through all those description of the parties, and now I'm referring to married persons, estates, customary marriages, civil unions, minors, insolvent persons, foreigners, trusts, companies, foreign companies, close corporations, fideicommissaries, usufructuaries. You must know how to describe them all. But once again, if you go to my book or you go to Javi Leroux's notes, there is description of all the parties there. And I always equate this, guys, that it's either right or it's wrong. It's black or it's white. You cannot have any gray areas. You cannot put the identity number below the status. It is the name, the identity number, and then the status. How are you going to describe? For instance, let me just, by way of an example, once again say to you that they give you an example. They say A bought the property in South Africa, and it's a woman, and she got married to a man who was domiciled in Botswana. Describe the transferee in your preamble of your deed. Now we know that foreigners or the marriages is governed by the laws of the country where the husband was domiciled when the marriage was entered into. The husband was domiciled in Botswana. So this is a foreign marriage. You're going to describe that woman that's buying the property as X, identity number, married, which marriage is governed by the laws of Botswana. Not married to, because she's acquiring the property now. Not married to so-and-so. It's X, identity number, married, which marriage is governed by the laws of Botswana. If you say married according to the laws of Botswana, believe me, it's wrong. They're going to mark you wrong. You're going to lose 5 marks because he's not married according to the laws. The marriage is governed by the laws. Now you're going to say, what the hell is the difference between? There is a subtle difference between that, okay? So just keep that in mind as well. So you must know foreign marriages, when is a marriage governed by the laws? Customary marriages, when is the marriage in community of property? When are you going to describe it as a polygamous marriage? All those things are set out in the circulars that we have given to you. The next clause in your power of attorney is the nomination clause. Now, once again, I've seen specifically people that are working in practices and in conveyancing practices, you know what they do? They recite all their conveyancers' names there. All their conveyancers' names. You only recite one name, and that is Joe Poe, with his LPC number. Do hereby nominate Joe Poe in my capacity as conveyancer to appear before the Registrar of Deeds, and hereby declare that Joe Poe with his number. Not 10 conveyancers with all their numbers. You haven't got time for that. That's where you lose time, and then you cannot complete your exam. So it's Joe Poe, and then with the LPC number, nominated and to appear before the Registrar of Deeds to pass transfer, and then the vesting clause, the person who's acquiring the property. Now, the vesting clause in your power of attorney is exactly the same as the vesting clause in your deed of transfer, and it will be as at date of registration. I usually tell conveyancers, and I know conveyancers are not doing this, the day that your deed is up for registration in the deeds office, you have to phone your seller and ask him if he's alive. Because if he's dead, your power of attorney has lapsed. If he's married in community of property, the transaction is ab initio void because his wife must consent in terms of section 15(2)(a). If he's been declared insolvent, he's no longer the owner. And so I can continue. You also have to phone your transferee or your purchaser and say, are you alive? Because if he's dead, it has to vest in the joint estate or the estate. So your transaction is as at date of registration. So the vesting clause, I say, the discussion under the vesting clause and analysis of the deed of transfer applies mutatis mutandis. The causa of your power of attorney, exactly the same as your causa in your deed of transfer. If it's a sale, if it's a donation, if it's an exchange, if it's a rectification, or if it's an inheritance, exactly the same. Property description, exactly the same as in your deed of transfer, with one subtle difference, that the extent does not have to be in words and figures. But if you want to put it in words and figures, and if you've got time for it, put it in words and figures. You're not going to be penalized for that. Then we have what we call a holding deed. We don't have a extending clause. It is just held by deed of transfer. Let's say it was a creation of a new entity. Then you say, as will more fully appear from the diagram, and lastly held. Okay? So please keep that in mind, that your form TT you will use with your power of attorney, but not your UU. Your UU you will cut down and only refer to the holding deed. We come to, we've done the property description, the holding deed, the creation of new conditions. This is very important, and here I want to refer you, for personal servitudes, look at the last proviso of section 65. For personal servitudes, look at the last proviso of section 65. You can reserve a personal servitude in favor of the transferor, or you can reserve a personal servitude, a negative personal servitude, in favor of a third party, provided it has been accepted. You cannot create conditions in favor of somebody that does not accept it, but you can only create negative personal servitudes in favor of third parties if they accept it. So look at section 65 for the creation of personal servitudes, specifically negative personal servitudes. Then let us look at section 69, which refers to positive personal servitudes. When can you create a usufruct, usus, or habitatio in favor, in the power of attorney? And 69 tells you that. Sorry, not 69, 67. Section 67 says you can only create a personal servitude of usufruct, usus, and habitatio in your power of attorney if it's in favor of the transferor or the transferor and his wife to whom he is married in community of property, or the surviving spouse of parties married in community of property. Now I want to explain this to you by way of an example. I die and I bequeath the property to my children, subject to a usufruct in favor of my wife. I married out of community of property. Can I create that usufruct in the power of attorney? No, it has to be created notarially because it is not in favor of my wife to whom I married in community of property. So there'll first have to be a cession and then the bare dominium will be transferred. Or for instance, I leave the property to my wife, subject to a usufruct in favor of my girlfriend, cannot be created in the power of attorney. She's a third party. So I always try and explain creation of positive personal servitudes of usufruct. As soon as it's in favor of a third person, it must be created notarially, if you understand that. If it's in favor of the transferor or the transferor and his spouse married in community of property or the survivor, it can be created in the power of attorney. So look specifically at section 67. For the creation of pradial servitudes, you go look at section 76. Pradial servitude can be created in your power of attorney if it is over or in favor of other property belonging to the transferor. As I repeat this, you can only create it in the power of attorney if it's over or in favor of other property belonging to the transferor. If you want to create it in favor of property not belonging to the transferor, it has to be created by virtue of a notarial deed. So, by way of an example again, I'm going to subdivide my property into portion 1 and the remaining extent. I'm going to transfer portion 1 to you and I'm going to retain the remaining extent. But to get to the road, I need a servitude over portion 1. Because now I've got block land, if you understand. So I can say in my power of attorney, entitled to a servitude of right of way over portion 1, because it's in favor of me over other land belonging to me or to somebody else. So just look at the provisions of section 76 for the creation of pradial servitudes. Then I want to refer to you to the last clause, and that remember, before you go to the signing clause, we always, in your normal run-of-the-mill, we have a general condition clause, and he can do anything that we might leave that out. We don't want that in the power of attorney. You don't write that into the power of attorney. You stop by your holding deed or your conditions. You stop there, and then you say, signed at Pretoria on such and such a date, and then 2 witnesses and the person signing. Now, the execution clause of your power of attorney, and I want to say to you, spot this also for the exams, Rule 63 of the High Court rules, as well as the Hague Convention. If a document is executed outside of the Republic of South Africa for use inside the Republic of South Africa, what are the rules of authentication? When can it be attested by a notary? When must it be attested by the ambassador of the country or the consul or whatever? And when can the Hague Convention apply? So those aspects of section the sections of the High Court, Rule 63 of the High Court rule and the Hague Convention read together with section 96 of the Deeds Registries Act. Guys, that brings me now to the end of my session, and now we have what we call a question and answer session. So I'm going to now stop here, and we're going to continue with the transfer duty receipt next Thursday afternoon at 2 o'clock. We have got 20 minutes now for questions, and as I said in the beginning, let us give let us restrict our questions to the aspects that we have now discussed up until here. I await your questions. Any questions, ladies and gentlemen?
I would like to ask a question.
You're welcome.
Okay, I want to find out, I think I know the answer, but I just want to make sure. For the extending clauses, if we start with the diagram and we annexed it there too, for the next, then they say, okay, now the transfer has been registered, then for the next one, we're going to keep on saying annexed, the next.
If it's annexed the first time, it will always be annexed.
Okay, and then for
But on that question, I just want to say to you, remember, there was a conference resolution in 2016, and please keep this in mind. If you're transferring the remainder, for instance, I've subdivided, let me, by way of an example, I've got Earth 182 Waterkloof, and I subdivide Earth 182 Waterkloof into portion 1 and the remaining extent. That was initially, when I bought it, it was on a general plan. To be able to subdivide that property, we can never subdivide from a general plan. I first have to get a mother diagram, and then I have to get a subdivisional diagram. So in my extending clause of my new entity that I'm creating, I'm going to say, as will more fully appear from diagram, and lastly, held by. In my remainder, if my remainder refers to a general plan and I'm transferring the remainder after I have subdivided, if I've subdivided it, then I cannot refer to the general plan relating thereto anymore. I must refer to first transferred by deed of transfer, number so-and-so. Then I'm going to remove with general plan so-and-so relating thereto, and I'm going to say, first transferred by deed of transfer with diagram so-and-so relating thereto, because it wasn't annexed thereto when I initially bought the property. It was relating thereto because it was created only years afterwards. Does that make sense to you?
Yeah, so that's only when you're dealing with the remainder.
Only when you're dealing with the remainder. And the remainder was, or the earth was initially on a general plan.
Okay. And then just back to just like, okay, not with a subdivision, but if your property was created by a general plan, then we'll keep on saying relating thereto in all, like going from TT to UU, and
absolutely,
we'll go relating.
As well as if it was firstly registered, you will continually say first registered, and relating and annexed. Those words will always stay the same.
Okay, great. Thank you.
You're welcome. Any more questions?
How important are sections 11 to 19 of the Alienation of Land Act?
Please don't regard this as a facetious answer. Unless you're going for the book prize, you haven't got time. So I wouldn't study 11 to 19, no. Because in practice, we very seldom get to deal with that. As I said, section 1, section 2, section 3, section 6, section 10, section 20, section 25, and 26. 29A as well. Those are the sections that you must have a good working knowledge of. But I repeat, I will, once again, when we go through the sections of the acts, I'm going to break that down again. I'm going to tell you, don't study this, because it's not necessary. I will do that again for you. Anybody else? If there's
Hi,
no,
Mr. West.
yes,
I'd like to find out, with regards to the statement of account that you mentioned with Mr. Theron,
yes,
is it important?
yes, yes. You and I think, if I'm not mistaken, you have been in a few of my conveyancing preparation classes, and we have clearly said there, and Anton has said it, that you don't have to finalize your statement of an account. You must know your debits and your credits. But guys, you won't believe this. People don't know the difference between debits and credits. You will get a mark for every correct debit and every correct credit. But you cannot put all your debits on the one side and all your credits on the other side and get 50%. Then they're going to obviously know that you don't know how to differentiate between a debit and a credit. So coming back to your statement of account, yes, it's important. Don't waste your time in trying to balance. You will lose at the most 3 marks if you don't balance. But you will get a mark for every correct entry that you put in. Anything else? But that question that you asked, I want you just to write that question down, because I want you next or the 22nd of October to ask that question to Anton again, okay? Because then they would have already prepared the exam paper.
Okay, maybe I can ask another question if there's nobody
Yes,
else.
you're welcome. You got 10 minutes.
Okay. Okay, so with the new government gazette and the circulars with regard to the LPC number.
Yes.
So for the power of attorney, we'll have it in the preamble, but also in the deed of transfer, must we also put it there for the PRO? We must also put LPC there.
It must be everywhere. Can I just answer this? You will have it in your preparation clause. You will have it in your nomination clause. You will have it in your preamble, and you will have it in your prep clause. So anywhere where you prep or where you refer to the conveyancer as an appearer, you will refer to the LPC number. And Audrey Gwangwa is going to issue a circular now for Cape Town. Bloemfontein has already issued a circular to say, just put the number. You don't have to say LPC number M so-and-so. You can just put in brackets 0001 or 0005 or what 007, whatever you want to call yourself. That's all that you have to put in brackets.
Okay, so unrelated, but then for other documents that we draft, we don't. Okay, the prep clause also, but maybe like say for 15B3, would we have to put it in there? Except now, if there's no prep clause there, but does it have to be everywhere that the conveyancer's name is?
Everywhere where you are preparing the document as a conveyancer or nominating somebody as a conveyancer. Okay. So if you're doing a application for a certificate of registered title as an example, your prep clause there, yes.
Okay. All right. Thank you.
Okay. Anybody else?
Mr. West, if I understand you correctly, in the prep clause, it will be prepared by me, conveyancer, and then you don't sign, but you put the LPC number.
You say prepared by me, conveyancer, Joe Poe, below, or next to that or below that, in brackets 007.
Okay, thank you.
I hope you're not all going to be 007 now. Anybody else, guys?
Hi, good day. Can you hear me?
Just give me your name that I can just sometimes put the name to the voice or the voice to the name.
You're speaking to Trishal Sharma.
Yes, Mr. Sharma.
I just wanted to find out how important would it be? Must we leave all of the half pages as per a deed and a power of attorney, or can we just draft continually?
Can I just say the power of attorney, you never leave a half page.
Yeah,
you start right at the top. The deed of transfer, the certificates of title, any deed that you're preparing, you must leave the upper half of the page blank. But what I tell, I've already seen this, that candidates write the whole question, and then they realize, oh my word, I didn't leave the half a page open, and they delete the whole question and they start all over, and then they can't finish the exam. If you just tell the examiner, I would have left the upper half of the first page, or put the asterisk and say, I would have left the upper half of the page blank. This just tells the examiner that you know what the practice is. Remember, your instruction is prepare the document as you would lodge it at the deeds office. So yes, preferably leave your upper half of the page, because you're going to put your preparation clause there, you're going to put your heading, and if you do forget, just put a little asterisk and say, I would have left the upper half of the page blank.
Okay, no, that's fine. And then we don't, and must we leave our so many centimeters?
No. You don't
have to do all of that.
Pages. You don't leave a margin. No. That's one of those myths.
Okay, no, great. Thank you so much.
Anybody else? Guys, while you're thinking of the questions, I want you now, you've got a week, and I want you to, this work that we went through today, and I'm speaking about the Alienation of Land Act, the recordal of the two contract, the recordal and the cancellation, the drafting of a deed of transfer and the description of the parties and causes and extending clauses, and the power of attorney. I want you to go and answer any questions that in old exam papers that contains this, so that you can determine whether you understand it. And I will take the first 10 minutes of next week's session, and I will say to you, let us see where your problems are, so that we can, because it's no good you continuing with something that you're unsure of, because that has a ripple effect and there's a snowball effect, and you're not going to be able to do the other transfers that we're going to deal with. So please, I need you. You got a whole week now just to prepare our 2-hour session of today. So if you want to pass this exam, you're not going to have any beers in the evening now. You're not going to sleep early anymore. You're going to prepare, because you, at the 11th of October, it's November, I mean, you want to cum this, or as my son called it, you're going to ace this exam, okay? Just a question that came up now. Am I going to do the transfers by endorsement? Yes, that is a session on its own. We're going to do section 45(1), section 45 bis 1A, 1B, capital 1A, and 1B. Once again, transfers by endorsement, extremely important, extremely important. Any other questions?
Mr. West, sorry, man. With regards to leaving a half page open in the deed of transfer, right? You already told us in your webinar that we're not going to...
I didn't hear you. Repeat that question.
Sorry, Mr. West. Can you hear me now?
I hear you.
You know, well, you said in your webinar that we're not going to be given a full deed of transfer to do. Let's say they tell us to draft just the causa and the vesting clause. Do we still leave half page open?
You do what?
Do we still leave half of the page open on the deed of transfer?
No, because you're not drafting a deed of transfer. If they ask you to lodge, to draft the causa, you draft the causa. If they ask you to draft a vesting clause, you draft a vesting. You're not drafting a deed of transfer.
Okay,
so
thank you.
I hope you understand that. If they ask you to, for instance, and please, you know, I've already seen this in the past as well. They ask you to describe the transfer law in a power of attorney. Then people draft the preparation clause, the heading. All that you need to draft is that clause and start with I, not anything else. Nooit. So once again, except if you're going to get a certificate of registered title or something, then you're going to leave a half page. But it's never necessary. And if that is there, as I said, you can put the asterisk. Anything else?
Sorry, sir. I said see 2 questions, one from Melissa and one from Sharice in the conversation box. I thought I might just mention that. This is Mariska speaking. I just saw their questions.
Okay, Mariska, give me your question.
No, Melissa and Sharice asked questions in the meeting chat. I just wanted to bring that to your attention.
I don't know. I haven't got the meeting chat open.
Okay, then maybe Melissa and Sharice, maybe you would like to. Melissa asked regarding the signing of documents overseas. It is quite expensive to sign documents before a notary in the UK, for example. Is it possible to prepare a one-page power of attorney to be signed before a notary, allowing someone else in South Africa to sign the transfer documents?
No, not at all. Not at all.
Okay.
If the document is signed in outside of the Republic of South Africa for use in the Republic of South Africa, Rule 63 or the Hague Convention must be complied with. So it doesn't matter if it's a one-page or a two-page or whatever the case may be, Rule 63 or the Hague Convention.
Okay, and then I see Sharice also asked a question. She asked for the power of attorney. Do we not put the general clause after the conditions?
No,
do we
I
go
said,
straight to the execution clause?
Don't. Please don't. And Anton is sitting next to me and he's shaking his head. And he said it so many times in the past. If you're going, look, they're not going to penalize you if you do it. You can do it, but you're going to waste time. Sometimes the examiners specifically say, omit the general clause. But irrespective of whether they say omit the general clause, don't put it in because you don't have time. It's not a legal requirement in any case. If you want to do we do it in practice because we want to have the capacity to do a 4-1B, if you understand what I mean. But it's not specifically for your purposes for the exams.
Okay, and then I just wanted to ask, I just want clarity regarding the resolution that you said we must not say at the end, we can say authorized thereto by ways of resolution, but we must not say held at this place and decided on this date, because then it shows that,
and close corporations.
Yes, so we must say authorized thereto by ways of resolution, but not the place and the date and all of those things.
Correct.
Okay.
I say once again, if you do it, you're not going to be penalized. But you're wasting time. And as I said, it is frowned upon because then they realize that you do not know what Chief Registrar Circular 8 of 1983 says.
Okay, so it's better just to say I'm acting in my capacity as director of the company. And
no,
then
you
not
must
refer
say,
to any resolution.
you must refer to by virtue of resolution, because it's either a resolution. If it's a power of attorney, you must refer to the full particulars of the power of attorney.
Okay, thank you so much.
You're welcome.
Mr. Allen, I just want to ask a question regarding statement of account. And I'm not sure if you're going to discuss it. It's Kristen. And I just found out if the purchase price include an amount for furniture, do you deduct the amount of the furniture when you do the
if I've sold my property inclusive and my deed of sale says 1.8 million rand and there's a clause which says including furniture, I pay on 1.8 million and that's my purchase price. I cannot deduct that. That is why I can't believe that lawyers will include that, because you're going to pay a conveyancing fee on that, you're going to pay transfer duty on that. You enter into a separate agreement for the furniture, the movables.
Okay, perfect. Thank you so much.
You're welcome. Is that it, ladies and gentlemen? I'll see you next Thursday at 2 o'clock, and please do your thing this week and let us see how far we get. Enjoy your evening.
Thank you. Enjoy.
Many thanks.
Thank you. Bye-bye.
Thank you.
Thank you.
Requesting from you. But before I carry on any further with my presentation, I have my guest here today, Mr. Anton Tron. Mr. Anton Tron is now just received the wonderful news this morning. He's the national convener again of the conveyancing exam. I don't know why he punishes himself like that, but he has decided to accept this
this onerous task. And I've asked him just to
Okay.
Meeting is finished now. Exit there now.
That's some features of the program.
Dynamic exposure to you are exposed to less violence, right? You become more active, enough time to play. You don't have, you have enough time to play.
Allow access, okay.